Okay.
Yeah, everyone else is black for me too.
Okay.
Weird.
Welcome everyone to Bar Talk May 13. It's a beautiful hump day, and we are, I think, supposed to be in a good bout of weather for the next week, which is great. For those of you that are staying on top of the executive order process or the PMO process at the judicial branch, tomorrow starts the first stakeholder meeting. And I think Angela is going to just present our second slide at some point, showing you that there has been a call out by a notice from the communications branch of the judicial branch to request any type of comments, concerns, etc., that the stakeholders meeting can address tomorrow. Also attached to this front slide is the way in which you can listen in on the live stream. I think it's going to be pretty much treated like they treat the law court arguments. Like we've asked before, if you do send a comment for the judicial branch through this comments COVID-19 courts.maine.gov email, please copy either Angela or I too, just so we've got an idea of what's been presented to them so that we can help coordinate the advocacy for those issues and questions. All right, that being said, we do have our special guest today, probate judge Michael Dubois from the Androscoggin County Probate Court. And he joins us, although some of us might be able to see him and some of us might not be able to. Judge Dubois, I appreciate you joining us. And the floor is yours to kind of like educate us a little bit on how you're running your court and how you anticipate running your court in the future.
Okay, thanks. And let me just start by saying, and I know other folks have commented on this process, this bar talk thing. I think this is fantastic. It's a brief way to sort of stay connected with what's going on, and hopefully some of you guys will continue to do this as time moves on. Let me start. I want to talk to you about just a couple of things. There's a couple of circumstances that have come into existence that impact the staff at the court, and there's also obviously some issues with the actual hearings that we're conducting. First off, some of you might know this, if you do probate law, we are restricted from gaining access to all of the nursing homes, hospitals, assisted living facilities, which impacts the ability of the visitors, which are the individuals that are assigned by the court to do a couple of functions. The first function that they do is serve a respondent with a notice of, let's say, a guardianship petition. And then the second thing they do is they actually interview the respondent to sort of get a flavor for what's going on, and they generate a report, and that's filed with the court. Obviously, that's been impacted in the sense that they can't access these folks. So the first thing, and what we've developed, is a process where the visitor will actually go over to the facility and personally get the petitions and the appropriate documents to an administrator who would then sign for it, and their titles obtained, their names obtained. And that's made part of the process that the visitor will get back to the court. The visitor then follows up with either a Zoom conference with the respondent or a telephone conference, and does a couple of things. It ensures that the individual, in fact, has received notice, has received a copy of the documents, and also does the interview that's required, and the information is gathered from that point. So that's worked out pretty well. It is a little more time consuming, but we're able to effectively get that service done and get that information in there. The second thing that happens is the statute, section 5307, requires that a respondent be physically present at a hearing, or that we provide alternative ways to do that. One of them is video conferencing. That seems to be working real well, because Most folks are, getting acclimated to using Zoom, for example, as a way to do that. So I'm finding that at the actual hearings, the respondents are in fact appearing via some video conferencing process, which was not happening before. We needed to go through a somewhat of an educational process to let folks know that in order for the respondent not to be present at a hearing, the statute mandates that we make a finding by clear and convincing evidence as to why they're not here. But I'm finding that that's not applicable generally because the video conferencing is working out very well. So I'm finding respondents are actually appearing at the hearings. These hearings I'm talking about are typically the return days that we do after a petition is started. We're not doing any contested hearings at this point. The Androscoggin County Courthouse, the whole building is physically closed, so nobody comes in to the clerk's office at all. So there's no activity in that building other than the employees that are working there. So we're not having any contested hearings. So all the hearings we've done have been consensual or they've been the return days to ascertain what do we do next. One of the processes that we're trying to figure out is, can we do a contested hearing? Under a rule of civil procedure 43, it allows us to take testimony from remote locations in certain circumstances. But that I've done some of those hearings historically prior to the pandemic where people have been incarcerated in a different state, for example, and we've done some video testimony taken through video process. The problem is you have a lawyer here in Maine who's representing somebody in Arkansas. And so it's a very cumbersome process where we're in the middle of a hearing. We've got to go off record and stop the process to allow the attorney to have a conference with their client, who's usually in a trial setting present and has that ability to have that contemporaneous input. That's not occurring. So a day-long hearing suddenly turns into 3 days. So we're trying to figure out if we can do some contested hearings, which are all on hold at this point. And it appears that if the clients or the parties could be present at a lawyer's office, for example, and we conducted testimony via different locations through video conferencing, that may be a little easier to do because the client can have access to their lawyer right in their office, but we haven't developed that at this point. We're still figuring out if first off, if we're going to need to do that, if this continues, and secondly, whether or not we can make that happen. The other problem would be documents. If there's a document-intensive case, we'd have to figure out a way to get all that information shared prior to that, so it doesn't delay things going on. So we're sort of thinking about doing that. Our building is closed until June 1. I spoke to the administrator the other day, and he anticipates opening unless there's some changes that occur after that. So it may not be something that we need to address. From a processing standpoint, we're down about 10% of the filings, which is not a huge number. And there's a couple of reasons I think that's happening. But in probate law, we do a lot of work with self-represented litigants. And historically, they would access the clerk's office, the registrar's office, and we would have a series of packets put together. For example, if somebody came in and wanted to have a guardianship from an adult petition, there's a few questions that are asked by the clerks, and there's a package that's already put together with all the necessary documentation, and they would fill that out. They can't do that anymore. So when they're calling the courts, we're directing these people obviously to the mainprobate.net. And there's a challenge in terms of what documents they think they need. And so we're finding there's a lot more telephonic communication between self-represented litigants and the staff at the courts. And it's taking up more time than normal for them. But by the same token, there's not as much foot traffic in there, so they're able to deal with that. They're able to get the work done that's normally done, and they just have to deal differently with the client, with the public, because once again, there's a lot of questions that are asked in terms of which forms should I file, how should I do this. We're finding that there's more self-represented litigants filing electronically, which is a change from what it historically has been. Lawyers have been doing it all along, so that's no changes there. So it works better for the probate courts. I think we're in a better position than the state court system because we've been electronically filing all along. Folks are accustomed to doing that. It's just at this point educating the self-represented litigants into that process, and we're finding that's going pretty smooth. It's a little more labor intensive once again for the staff, but they're able to handle that. We're not. Yeah.
Judge Dubois, sorry. We're almost out of time. I know that. Yeah, I just wanted to touch base with you about a couple things, and you can certainly have your final say too. I wanted to ask, how do you get original wills delivered to your court if your whole building is closed?
Well, the United States Postal Service is still working, so that's how we're getting them. So, and I think that's not an unusual step. Beg your pardon?
I was just saying, so that's you haven't had people insist on hand delivering the original will?
No, we have not. And I assume you're talking about in the context of an estate filing, that they want to get the original will in there. Yeah, no, no, mail works good. It's not an issue at all. That's falling fine. That's all I had to add. Anyways, go ahead.
Okay, and then we had another question from a constituent outside of your county that was asking about whether or not you apply the 49-day rule that the state, through the PMO process, the state judicial branch has put together for extending deadlines such as discovery or any other deadline mandated by the court.
Yes, we've been following the pandemic management orders, and I believe the deadline you're referring to is scheduled to expire fairly quickly here. So I'll echo. Yeah, so I'll echo what was mentioned, I think, last week by Justice Meade, that you should assume that that's in effect and those deadlines are going to expire, and that's what it is. There's been no extension that I'm aware of at this point, so I would proceed in that fashion.
Well, thank you very much, Judge Dubois, for your time here. And there may be some other questions that come up while we're talking, if you have the ability to stay on. Angela, did you want to hit the business side?
I do. And I'm wondering if maybe some of the issues that we seem to be experiencing today are because I updated my Zoom this morning. And if for those of you who have Zoom, you've probably received notice that Zoom 5.0 is now available, but effective May 30th, everyone will be required to be on Zoom 5.0. So some of us have it now, some of us have installed it, some haven't, and it makes me think that maybe that's why there's a little bit of lag time today. But basically, Zoom's going to be enabling GCM encryption across the entire Zoom platform to make it increase the protection for our meeting data. So I would suggest to all of you that if you use Zoom on a regular basis, that you go in and you upgrade to Zoom 5.0, because come May 30th, if you try to get on a meeting and you haven't upgraded and you think you're just going to hop on a meeting real quick, you're not going to be able to hop on because they're going to make you do the download at that time. And I don't want you to get caught being late for something that you think you're supposed to be on. I did have a question the other day about the platform that courts are using for video conferencing, and what I was told from Amy Quinlan is that they're mostly using Google Meets for video conferencing. So I will also reply to that email. And finally, you'll see that we have another probate judge joining us tomorrow. Bar counsel will be joining us on Friday, and it's our hope that we'll have the MSBA representatives to the stakeholders group join us on Monday to let us know some information about tomorrow's stakeholder meeting.
Great. Thank you, Angela. On the personal side, I just wanted to say we've got to be thankful for our law students, our future lawyers coming through, and they're all pretty much wrapped up with their finals at the Maine Law School as of, I think, right about now. So there may be some looking for some experiences. Keep them in mind. With that, I know we're out of time. We look forward to seeing you tomorrow. Thank you, Judge. Thank you, everyone.
Thad, I just had a quick question as to whether or not there'll be a bar talk tomorrow at 11. I think that's
Yes.
with respect to the fact that the stakeholder meeting starts at 9:30.
Right. And there will be one at 11. We have no idea when that stakeholder meeting will end. And we'll go from there, I guess.
So at this point, yes, we will have one, and if hopefully we'll have a little information from that meeting, but if not, we'll have to talk about it on Friday. Thank you all.
Yep, or Monday. See ya.